I bet you didn't know that hiring a lawyer might be the wrong move for you. Being pro se might be the wrong move for you. How do you know which is right for you? Stay tuned. I'm going to get into it today.
Welcome to Self-Represented in Family Court, the only podcast you need if you're feeling lost, stuck, or overwhelmed in family court. At Self-Represented, we don't waste time discussing the law like all the other podcasts. We focus on what really matters in your divorce or custody case. That's strategy. With your host, Tracey Bee, former family law attorney turned pro se family court strategist.
Hi, it's Tracey Bee, and you're listening to another episode of Self-Represented in Family Court. Welcome. If you're new, welcome. If you're a repeat visitor, thank you for showing up again today. So I wanted to talk about something specific. As you all know, except the newcomers, of course, I generally pick topics that are hot amongst discussion groups, in Reddit groups, social media posts, wherever I think there's something really intriguing, especially if it's something that gets asked or addressed or discussed often. That's where I use get my topics from. And today is no different. So lately, what I've been seeing and hearing and reading is that people are either going from lawyer to pro se or pro se to lawyer, either full on lawyer representation or a somewhat hybrid situation. And I'm not going to talk about the hybrid situations today. I'm going to talk about pro se to lawyer and lawyer to pro se. And I'm addressing this today because it's been an interesting discussion from quite a few people particularly about going pro se after having had an attorney. And some people choose to go pro se because they think they can do a better job, or disappointed with the way the lawyers are moving, or have spent enough money and don't want to spend another dime. There's a myriad of reasons, but people are also forced to go pro se where they just run out of money, or they can't find an attorney that is available to handle their case, or, a combination of those. So either way though, if you are forced or by choice pro se after having a lawyer represent you, then you absolutely need to be aware of things that you are or should do from a practical standpoint, but also from a strategic standpoint. So let's start with the practical. When you have an attorney and, the attorney might withdraw because of, disagreements or lack of payment or whatever the case may be, lawyers have to withdraw by application to the court. That means they have to seek the permission of the court to withdraw. Whatever the reasons are, whatever their reasons for wanting to remove themselves from your case, they have to get permission from the judge. And believe it or not, some judges will force attorneys to stay on the case for maybe a specified period, or to reach a certain point or accomplish a specific goal, or to finish one specific issue up, whatever. The judges do have the authority to force a lawyer who has asked to be relieved to stay on the case. It doesn't happen often, but I've seen it happen. I've seen judges tell counsel that they are to stay on the case at least until, a hearing is done or discovery is exchanged, or, whatever. And sometimes they'll make allowances, telling the lawyer that they could get some sort of remuneration from the client for that work, or enter a judgment, or, whatever the judge is comfortable doing. But the judge can deny a lawyer's request to be relieved. What does that mean in spirit though? In practice, a pissed off lawyer, pretty much. And, a judge who may not be all that happy either, because sometimes when lawyers ask to be relieved, it inconveniences the court. The court is most concerned with the efficiency of moving the cases along, of meeting, the court imposed deadlines that may be in place, or, just because sometimes out of spite. But the reality is judges are not always a fan of a lawyer who comes into court asking to be removed from a case, despite the reason, how justified the reason is. Because again, the judges, even though judges and lawyers, are comrades and, cronies, and, they are friends and buddies and dine out together and vacation together, most judges still have the motives to move cases along to meet certain guidelines, certain deadlines that are imposed by itself or by, as I said, court mandates that are issued either statewide or jurisdiction-wide. Yeah, judges are not always excited to see a motion on their desk where an attorney's asking to be relieved. So in a case where the judge grants the relief, though, that means that the lawyer has the right to basically leave you exactly where you are. They don't have to wrap up anything. They don't have to finish anything. They don't have to explain anything further. They don't have to discuss anything further with you. Once the order is issued that they are to be relieved, or they can relieve themselves from the case, they pretty much don't have an obligation to you at all. So what does that mean? That means that if you need some further guidance as to where you ought to pick up, where the lawyer left off, if you need some additional information to move forward, if you need your case files, if you need any sort of communication from the attorney regarding your case, they are not obligated to do that. They're not obligated to respond to you. They should maybe, but they're not obligated. So if you are this pro se litigant, you just found yourself in the position to be pro se now because your lawyer was actually relieved, then it's best that you start to, dig right in, jump right in, and find out exactly what you can find out. You can find your court status, what's happened in court. You can find all that stuff by going to court yourself. Once the attorney is no longer in your case, they should turn over the file to you. But again, they don't have to. In some states, they are allowed to put a lien on the file and hold the file until you pay them. And in some places, they just are not allowed to do that. But even when they turn over the file, they may only give you the stuff that is actually in the court's possession, the documents that are, basically filed in court. Any sort of communication between them and the opposing counsel, any work that they've done, they don't have to turn that stuff over because it is protected by work product or privilege, not privilege, work product rules in most jurisdictions. So it is best that once you know the attorney is no longer representing you, it is best that you start by going to the courthouse and figuring out what you need to file if there's a formal requirement for you to file to notify the court that you are now pro se and that any communication should be directed, towards you and not your attorney anymore, because that can create a nightmare. And that that the opposing party / counsel are made aware of the fact that you are pro se, and that, again, any communication, documents, or whatever should be directed at you. So once you do that, the next thing you want to do is go to the courtroom's clerk or record room and actually get a copy of everything in the court's file. Everything the court has on your case, you want an actual copy of it. Some places you can actually go online and they have portals where you can download that stuff. But if not, I prefer going to the courthouse anyway, because some things just don't make it to scan. And even though some places are more efficient than others, I'm just paranoid about things like that. So I'd physically go and get a physical copy of everything that was filed or submitted to the court in your case. That's what you should do. That's the second thing you should do. The third thing you should do is, after reviewing everything, because that's the third thing you should be doing, is reviewing everything that you have obtained. Review everything that you've gotten from the court, that you've gotten from your previous attorney. Organize it, categorize it, prioritize it, analyze it, so that you could decide what's your next move. And that is a critical part of your case, because a lot of times, by the time a lawyer asks to be relieved, the communication between you and the lawyer has broken down to the point where you don't even have a clue as what's going on or what's happened most recently in your case. And so you need to be, brought up to speed in that respect. So it's a great idea for you to take everything that you've gotten and take a few hours and go through everything, labeling things, understanding things, organizing things, categorizing things, so that you know what your next move is going to be. It's also going to require you to do a little bit of research, which is number 4. You should definitely be doing your research. Once you have your file and you know that you're going to be pro se, you absolutely need to do research. You need to find reliable sources online, not social media, online, whether it be the court's website, whether it be other websites that are really helpful and insightful with giving you information about laws for your state and rules of procedure for your state. You should be doing the research. Go to the law library at the courthouse, go online and check out websites like justia.com and start to do the research. Take notes. Be sure to understand exactly what's happened in your case, what didn't happen, and what should or could happen. The 5th thing you should do is to, see if there's any deadlines coming up. If there's any deadlines coming up, then you want to, and the reason I say do research before the deadlines is because you need to know exactly what the laws and the rules of procedure that are going to apply to you with respect to the deadlines, because some deadlines are written in stone and some aren't. Sometimes there are some exceptions or some shortcuts or some workarounds to deadlines. And you're only going to know that by familiarizing yourself with the rules of court procedure for your specific jurisdiction. And calendar those dates. Make sure you have your supplies, your pads, your folders, your notebook, your highlighters, your calendars, your apps. Make sure you're prepared, because being pro se is going to be like taking on a full-time job for some a part-time job, but it's definitely a job, especially if your case is a high conflict case and it's probably going to go through the whole litigation process. You absolutely need to be sure that you have the tools you need to be organized, to be prepared, and to make sure you are, presenting your case in the most cohesive and persuasive way possible. And those tools are going to help you. In addition to setting up a ChatGPT account, that's going to be really helpful for you too. Not to work on strategy or legal analysis, but to help you stay organized. And so after you've done all that, then you want to, decide if you need to file anything, if you need to submit anything, if you need to gather some information and prepare it for, whatever the next court date is. That's what you're going to have to focus on. After you've done all that, then you might want to reach out to the other side to discuss the possibility of settlement. And yes, your previous attorney might have discussed settlement, before they actually were relieved, but they might not have, or they may not have been as successful as you might be in discussing settlement. So you are obligated to communicate with the opposing counsel, and the opposing counsel is obligated to communicate with you. The thing is, the best way to communicate is by email. Try not to have any in-person conversations, any over-the-phone conversations. It's best to communicate with them by email. And then when you're talking about serious issues, also by regular mail, sending them an actual hard copy of some of your communication, like settlement proposal offer. I would definitely send that by hard copy and email, just to be on the safe side. And then once you do that, you'll get their response or not. And then you'll be prepared to move forward with, going to court and, moving on to the next step, whatever that might be. If there's a hearing coming up, you might want to, certainly, if it's a hearing for a request that you made, then again, it's a good idea to reach out to opposing counsel to see if there's some sort of settlement that's possible. If it's a hearing that's coming up for a request that the other party has made, then you may want to, it's not a bad idea to attempt to resolve things, but then you might be less successful at that, depending on the background of your case. But it doesn't mean that you shouldn't. It just means that you might just be doing it as a strategic move, because a lot of time, most judges would love to see that you've attempted to resolve things. That's one of the things as pro se that I tell people to do often, is to reach out to the other side in a formal manner, asking them if they are interested in a settlement. And when you do that, be sure that the settlement is not outlandish or ridiculous, because it sort of is counterintuitive to try to, show the judge that you are the one trying to resolve the matter when you are making unreasonable offers to begin with. That's not in good faith. That's not something that a judge would think, hey, yes, I'm going to credit you or give you credit for attempting to resolve this outside of court, when they're not going to do that when your offer is ridiculous or outlandish to begin with. So now you're pro se, and now the other opposing counsel, the judge, the court staff, everyone is or should be made aware of the fact that you are pro se. You are pro se. The lawyer is not going to be comfortable communicating with you now that you are pro se, especially when they've had the convenience of talking to an attorney that they might be familiar with. And now here you are pro se, and someone they've never had any direct communication with because they didn't have the chance to, since you had an attorney prior. The judges might not be a fan of the fact that you had an attorney, and now you've made this huge major shift in your case, and you are self-representing, which makes the court tend to believe that the case is going to take longer than necessary. There's going to be some unnecessary delays and stalls and, hiccups along the way, because you're not familiar with the court rules, with court procedure, with laws, with decorum. They're going to assume that. So they're not going to be pleased. And then the court personnel, some of them are going to tell you, hey, listen, you decided to be pro se. We're not obligated to help you. We are not allowed to give you legal advice or to assist you in any way. We can answer basic questions, but that's about it. So you're gonna have some challenges as pro se, especially when you've come from having an attorney. You're creating a different landscape now. That means things are going to have to move differently now. Things are going to take longer. Things are going to be a little bit more complicated. Things might be a little bit more antagonistic, actually, because the judge is not really a fan of you being pro se, and opposing counsel is not really overcome with joy by the fact that you're pro se. And the court personnel are not going to like to see you coming since you're pro se, and you're going to have a bunch of questions. But you have the right to be pro se, and don't let them intimidate you. This is your right to do that. It's just really, really important that you understand the role that you're about to take on, that no one's going to hold your hand. No one's going to give you a pass. No one's going to go easy on you. No one's going to do that. No one, absolutely no one. No one's going to do that, because again, you've changed the landscape now. A case that they thought was just maybe mid-conflict or medium conflict, they're going to assume that now it's going to meet the level of high conflict, because here you are self-representing in a situation where, things were moving along, so to speak, because there were attorneys involved. So don't expect a fanfare. Don't expect a big celebration. Don't expect a attaboy or attagirl from any of the key players, because that's just not what they're going to do. They're more likely to be the opposite, or to respond in the opposite manner, because of the fact that you decided to, or you were forced to be pro se. So if you have issues with self-representing when it comes to preparing your case, presenting your case, positioning your case, that's where it helps to have someone like myself to guide you along the way. When you're pro se, especially after having an attorney who's handled all those things for you, it's going to be a shock to your core to see all the answers, all the information, all the education, the insight, all that you have to learn. And sometimes in lightning speed, you don't have time to ingest it all, because you have something coming up that's really important. So it's helpful to have somebody like myself who knows the family court process, who knows the law, who knows procedure, who knows strategy to guide you through that. And when you work with somebody like myself as pro se, especially after having an attorney who's managed everything for you, all you had to do was really show up. It's helpful to have someone who's going to cover those blind spots that you're just not going to see. Because when you were represented by a lawyer, you didn't really know that there were blind spots because the lawyer took care of those things. The lawyer had a paralegal, a legal assistant, legal secretary. They had support staff that helped them cover those blind spots. Well, you don't. You're literally on your own. You don't have a support staff. You don't have access to Westlaw or Nexus like the attorney does. You don't have the AI subscriptions that are specifically geared towards helping lawyers do proficient research and document drafting and those kind of things. You don't have all of those things. You may have a version of some of those things, but it's not going to be as efficient and as professional as the ones that are geared specifically towards lawyers. So now you have to step in the role of, you've already have this complicated role of being spouse and or parent, and now you're litigant, pro se litigant, in addition to all of that. So this is going to be a huge feat you're taking on, and it's really helpful for you to have somebody like myself who understands not just family law, but the family court process. That is my area of specialty, the family court process, because the family court process itself is the part of the case that most attorneys don't really take the time to explain to litigants, because they have their support staff that helps them navigate that, or they're just so familiar that they know they have a system or method that they've put in place to help them get through that. No one's going to tell you that. No one's going to explain those things to you. No one's going to explain to you courtroom decorum and court staff interaction and roles and obligations and responsibilities. No one's going to explain those things to you, but I will. So if decided that you needed that sort of guidance and that support and that assistance, which is actually going to help you not just increase your chances of succeeding at your outcome, but it's going to make the experience for you a lot more bearable than if you are completely pro se, completely on your own. So think about that. So we've discussed going from lawyer represented to pro se. Now let's talk about the opposite. Going from pro se to now you want to engage a lawyer. Now you want to get a lawyer involved in your case. There is situations and circumstances where that's what people do. They start off pro se, and at some point they decide, you know what? I need to hire a lawyer. Whether it's because they have the resources now or the means, things are getting complicated and they need some help, or they just don't have the time commitment or the attention or the bandwidth to pursue pro se anymore, and they would like someone to go ahead and take control. In that case, you don't really need anybody's permission to go from pro se to lawyer represented. You don't need a judge's intervention, nor does a lawyer. You just simply go and meet with some lawyers and choose which lawyer is going to be the best one to work with to achieve your goals. I will say this though. When you go from pro se to lawyer represented, your perspective is very different than if it were the opposite. Because when you were lawyer represented and you became pro se, you more than likely gave over most control to the lawyer. You deferred to the lawyer and you trusted them to manage and take care of everything. Well, that's different when you start out as pro se. When you start out as pro se, you are more informed, you're more in control, you're more aware, you're more capable, you're more organized, you're usually more prepared. Because if you've started as pro se on a brand new case, especially, then you've more than likely taken the time to familiarize yourself with the laws, the procedures, the rules for your specific jurisdiction. And once you do that, now even your mindset is very different. You understand things from a different perspective, and so you're a lot more capable and able to assist any lawyer who's going to take over your case in a way that's going to be more advantageous to you. You're going to work more like a collaborative team, as opposed to, when you're a lawyer represented and you gave full control over to the lawyer. It's going to be very different. You're going to have different expectations of the lawyer. You're going to be clearer about what their role is, and you're going to be a little bit more aligned with your goals, what your goals are, and how to actually accomplish them when you go from pro se to lawyer represented. So some people decide to hire a lawyer after they gotten through the initial stages of the case. I often suggest to people, if you're going to start a case, especially a divorce case, you don't need to run out and spend a $10,000 or $15,000 retainer to hire a lawyer. Save that money, start the case on your own, do the research on the court's website, learn the rules and the procedure, get the case started on your own, get to the point where there's either mediation or your first court appearance. Go there pro se as well. And then after that, you can decide if you are able to proceed pro se or if you actually need to hire an attorney. And I say this, because there's a lot of times, I can't tell you the number of times people have said to me, hey, I've already spent $10,000 and we've gotten nowhere. We haven't even made it to mediation, our first court appearance, and I don't have another $10,000. And so I say to people, just from hearing that so often, now I recommend people file pro se, get things started pro se, and then at some point, if necessary, because some people are just capable of handling a case pro se from beginning to end. And at some point, whether it be the first court appearance or the second court appearance, you're going to hire an attorney then. That way it gives you it doesn't just save you money, it gives you more control. You are more educated, you are more informed. And so you're going to make better decisions. You're going to maintain a lot of the control. You're not going to have this disappointing, frustrating dynamics that you have to deal with that's going to set you back because you're stressed out and you're unable to focus or concentrate on your overall mission. And so, start the case on your own and go to mediation. You don't absolutely need an attorney to go to mediation. I mean, I know for some people, they feel more comfortable having an attorney because, especially when there's been power imbalances in the relationship, they'd rather have an attorney go to mediation to help speak up for them. But if you are okay with speaking up for yourself at mediation, and mediation is usually a pretty peaceful, calm environment if the mediator is, doing their job. So you can actually, go to mediation pro se and see how that turns out. I suggest that to people quite often. You can even go to your first court appearance, whether mediation works or not, your first court appearance where you're before the judge. You can even do that pro se. In fact, you should, because that's the best way to get to know who your judge is and how they perceive pro se. That's the only way to know, because you don't want to be in a former situation where you have an attorney and you find out, later on in your case where it's, closer to the middle or the end. And then that's when you find out how the judge feels about pro se. You want to know that as early on as possible. And people can tell you all day how your judge is going to treat you as pro se. Nothing better than actually seeing it and living it for yourself. So you can go to the first court appearance pro se and get familiar and get acquainted with the judge and see how they do things and see how they perceive pro se. And you could decide after that you might want to hire an attorney because you see that the judge is not in favor of you being pro se, or the judge is not a fan of pro se. And so you feel like you have a better chance if you had an attorney who would advocate there for you. So either way, though, you can do the filing, the serving, the mediation, the first court appearance. You can conceivably do that pro se. And once you do that, and you decide that you want to hire an attorney after that, you decide after the first court appearance that it's, there's several reasons why it will be beneficial to you to go ahead and hire an attorney. Now you're going to go and screen attorneys. So when you screen these attorneys and you vet these attorneys and you meet with these attorneys, you're going to have better questions set up for them because you've already gotten a taste and a feel for the process. You're not going in blindly and making yourself vulnerable to attorneys who tend to take advantage of people who come to them right from the gate, desperate and afraid and ready to, to lay out the $10,000 cash retainer. They don't know anything. They don't know what to ask. They don't know what to expect because they just have no connection, no insight, no experience with the family court process at all. You're not them. You're going to be at an advantage because now. You're familiar with filing and the court house and the judge and the process. You're familiar. So you're already at an advantage. You're already at an advantage when you're meeting with attorneys. So now you can choose an attorney that's more aligned with your goal, with your style, with the specific judge, with the issues, with your opposing party, or if they have an attorney, you're going to know. You're going to know how to pick a better attorney. Believe it or not, you will. Not to mention, once you start the case pro se, you'll know the opposing counsel. You'll know if the other party has an attorney. You get to see for yourself, not just through what your attorney tells you about opposing counsel. You'll get to see for yourself. You'll get to experience how they operate, how they move. If you ever want to see an attorney, whether or not they can really be a POS, deal with them as pro se. Because a lot of attorneys just do not want to deal with pro se, and the ugly will come out of them. Give it a shot. I challenge you, give it a shot. Be pro se for the first portion of your case and deal with opposing counsel and just get an idea of who they really are. And then that way, again, when you go to interview and vet and screen attorneys that you might want to hire, you can really pick an attorney who you think is going to be a great match for opposing counsel. Believe me. Another advantage is that you're going to save tons of money, not just because you've done this, but because you are more inclined to be a team member, a team player. You'll work with the attorney as a team. You won't give over complete control with them. You'll be proactive. That's what I call a proactive lawyer represented litigant. There's pro se, and then there's proactive lawyer represented. You'll be a proactive lawyer represented instead of an inactive lawyer represented. You'll save time, you'll save stress, you'll save yourself so much heartache when you do that. And for some of you, you have to actually hire an attorney because you can only do so much on your own. You just don't have the time. And even when you don't have the time, having a lawyer and being proactive, you're still going to manage the time, the little time that you do have, more efficiently. So some things to consider going from pro se to lawyer represented is the lawyer is going to respect what you've accomplished if you've managed to be pro se and learn to be prepared and organized and all of those things. The lawyer is going to have a different level of respect for you as long as you show them that you were pro se, but you were not just pro se, but you were pro se responsibly. You were a responsible pro se. You've done the work, kept up with deadlines. You've learned what you needed to learn. You've actually put in the work. They are going to respect you. And I can't stress to you how much your rapport with your attorney affects the way your attorney goes and advocates for you. Attorneys work harder for people they like and respect. Trust me, they're human. Lawyers are human. We're all human. So they're going to have a genuine respect for you if you show up to them organized, confident, articulate, knowledgeable, prepared. And a lot of times starting your case pro se will get you in line to be all of those things. If not, then yes, go ahead and hire a lawyer. Go ahead and hire a lawyer and let them do that stuff for you. So some of the other things that you have to consider is the judge. The judge now, who might not have liked you before, may start to treat you a little bit differently, may hear your case a little differently, may issue rulings or court orders that are a little more favorable to you because now they don't see you as a threat anymore because you're not self-representing and you're not going to, bring the issues to the court that are typical with pro se litigants. Even the court personnel and the court staff, they're not may, because you won't have as much interaction with them because you have a lawyer now. But if you, in the event that you are, or that you have to, they may not be so hostile and not be so apprehensive about, responding or helping you out when they know you have an attorney. That's tricky because most of them will limit interaction with you to just dealing directly with your attorney. But again, it depends on what those issues are. The challenge, though, of going from pro se to lawyer represented is you can't file anything on your own anymore. You can't file petitions, motions. You can't file them. The lawyer has to do those things on your behalf, or they just won't get done, because you can't have a lawyer fully represent you and still do filings. Now, there's situations where there are hybrids. Well, I will discuss that next time. But for right now, I'm just talking about having a lawyer fully represent you in your case. You can't represent you. Yeah, in most cases, unless the judge gives you permission or the judge directs a question specifically towards you, you won't be able to speak for yourself anymore. The lawyer, that is entirely the lawyer's job. And the same thing with opposing counsel. You can still have communication with the opposing party, but you can no longer communicate with the opposing counsel. That's going to be, again, entirely up to you, your lawyer. What can you do? Well, what your lawyer feels comfortable with you doing. You can still gather information. You can still do research. You can still do some of the practical stuff like arranging filings or servings, having someone served, or, getting a hold of documents or records. You can still do some of those things. But, as far as communicating with the opposing counsel or with the court or filings, no, you can no longer do that. I think I covered everything I wanted to cover. If I didn't, just please feel free to email me and ask me specifically about your scenario. And I will definitely, love to answer as much as I can for you. If you want to work with me, if you are pro se in either of those scenarios, starting out as pro se and thinking about hiring a lawyer, that's definitely something we could talk about, whether or not you should, whether or not this is the time, or if you are, you started out having a lawyer and now you're pro se and now you're scared out of your pants and you want to talk about what that is going to look like for you. We can discuss that as well. I do 1-hour strategy sessions where we talk about whether pro se is for you right now, whether there's a hybrid situation that works for you, whether you and I can do it together. We can talk about that in an hour session, and you will learn so much in that hour. You will learn so much. You will learn the pros and cons, the challenges, and the strategic ways of addressing whatever those challenges are. So anyway, that's all I have for you today. Thank you so much for tuning in. I hope you to join us next week. Take care.
If you're having an active family court case and something already feels off, you need to identify where your case is seriously exposed. Schedule a strategy session now so we can shield your case from more damage. You can't afford to keep guessing. It's costing you way too much.